All right. Thank you. And so we're moving on now to Interim Charge 4 on electronic materials. This is where the committee will review the methods used by state agencies and courts to prepare and publish electronic legal materials. It will examine the processes used to ensure reliability and permanence of these materials and strategies used to harmonize those processes with national standards, including the possible adoption of the Uniform Electronic Legal Materials Act. Panel number 1, the chair calls Mary Camp with the Legislative Reference Library. Do we have forms on everybody?
We have forms. There's actually one more person.
Okay.
Lisa Rush.
Lisa Rush. All right. Who's she with?
She's a law librarian, library manager.
Here?
In Austin, yes.
Okay. We also have Jane O'Connell with the Tarleton Law Library at the University of Texas, if you'll come forward, and Barbara Bentiff with the Tarleton Law Library, University of Texas, and Lisa Rush with a Law Library Management here in Austin.
I was going to start with one of the law librarians. Okay, let's go first.
All right. The intent is to start with the law librarians, whoever would like to start first. All right, if you'll state your name and who you represent. Yeah, sorry, we're having to share that one mic.
Thank you and good morning. My name is Barbara Bentliff. I'm the director of the Tarleton Law Library at the University of Texas, and I'm joined here by my colleague Jane O'Connell, who is the deputy director of Tarleton. I need to note here that neither of us is speaking in an official capacity as an employee of the University of Texas. We are speaking only for ourselves. I would like to take this time to tell you what the Uniform Electronic Legal Material Act is and why it is important to Texas. Citizens of Texas need to know what the law is. We are bound by the law. And equally important, knowing what the law says is an essential component of effective participation in the democratic process. It is a basic democratic process. It is a basic responsibility of citizenship. The state government needs to ensure that official, up-to-date, and accurate law is available. We citizens have to be able to trust the law that we find. In addition, sometimes we need to know what the law used to be, because repealed or overruled law can determine our rights. That means that the primary sources of law need to be saved or preserved into the future. Texas law has long been available electronically through subscription databases like Westlaw and Lexis, and the state of Texas itself publishes some law electronically. Publication by the state makes the law directly available to citizens, which furthers accountability and transparency of governmental services. It reduces the cost to citizens of finding law because it means we do not have to purchase expensive books or databases to find out about our rights and responsibilities. As Texas increases its electronic publishing of law, our government needs guidelines for dealing with that electronic law. It is important to ensure that the electronic law is trustworthy or authentic, that it is permanently preserved for future use, and that it is easily accessible to the citizens who need to use it. The Uniform Electronic Legal Material Act, we call it UELMA, which sounds like my aunt, is intended to serve as a guideline for states that are publishing their law electronically. UELMA would allow Texas to proactively provide these guidelines to its various governmental entities and agencies, so citizens and other users of electronic legal information can use our online law with the same confidence as they would use print legal information. UELMA requires a system of authentication for official electronic law. Under UELMA, Texas would prepare its legal material for electronic publication the same way it does today. Once the electronic law is made available to the public, authentication is a straightforward process. Essentially, a software program notifies the citizen if there has been an interruption in the path of the legal information from the Texas government server to the citizen's computer. An interruption would indicate that the text of the law may have been altered and prompt the citizen to check the state's definitive source of the law to ensure its accuracy. Authentication does not require action on the part of a state official. It is purely an automated process handled by software. There are several ways to provide for authentication. Some states use digital signatures, some use hashing, and some use a public key infrastructure. Minnesota has developed its own system, and I believe North Dakota is doing the same. The U.S. Open Data Institute is creating open source software freely available expressly for this purpose. 6 of the 9 states that have enacted UELMA have projected no fiscal impact with its implementation. UELMA also requires that the state keep safe or preserve all electronic law that is or was official. The law can be preserved in print or in electronic form. And UELMA requires that the preserved electronic law be made reasonably available to citizens and other users. UELMA brings efficiency and cost savings to administrative and court proceedings because it offers reciprocity among enacting states. Texas electronic law will automatically be given a presumption of authenticity in those states that have also enacted the statute, and the law of those states will be presumptively authentic in Texas. UELMA is citizen-friendly. It is an outcomes-based, technology-neutral act that leaves much discretion to the Texas legislature in terms of the specific legal material covered. Only the Constitution, session laws, the statutory code, and regulations with the effect of law are required to be covered by UELMA. All other materials are discretionary in keeping with the principles of separation of power. UELMA also offers discretion in terms of authentication method and the process used to preserve and make the law available. UELMA furthers governmental transparency and accountability. It makes court and administrative proceedings more efficient, and it ensures that our electronic law, the laws you pass, is preserved into the future. I thank you for this opportunity to speak, and I would be happy to answer any questions.
Members, any questions? I have a question. When or how many states have adopted UELMA?
At this time, 9 states have adopted, and it's pending in 6 others, I believe.
And is it a sample? What are those states, sort of? Are they?
California, Colorado, Connecticut, Hawaii, Idaho, Minnesota, Nevada, North Dakota, and Oregon.
And when was the UELMA initiated? When
it was finally adopted in July 2011.
And last question, what would be the state portal? Or so I'm a citizen and I'm looking something up. I mean, where would this come out of? I mean, a lot of people know elections, you go to the Secretary of State, for instance. So would this come out of, would this be perhaps from the legislature or the Supreme Court? Or
that is certainly a decision that you would make in the process of determining whether or not you are going to adopt UELMA. Hopefully we would have one portal for all state law, but it could be that the legislature continues to offer its electronic information through the legislature. If court decisions or other documents are included, it could be that the court would offer those. If gubernatorial or executive department publications were included, those could be offered through that branch of government, or there could be a combined portal, and that's very much a decision that you would be able to make.
I'm sorry, one last question. So I'm trying to see, how would this interface then with the private services, LexisNexis, Westlaw?
States have been publishing their electronic law for a decade or more, and it has had minimal impact on Lexis and Westlaw and other electronic database vendors. In fact, we had representatives from Lexis and Westlaw and other database vendors on the drafting set of observers. They weren't members of the committee, but they were at all the meetings. They support this too. We find that what we call value added, the features that Lexis and Westlaw add to a statute when they put it online, still make them very, very appealing to attorneys and practitioners who are using electronic legal materials because it aids the research process. And so there hasn't been a significant impact, as far as we are aware, on Westlaw and Lexis by the movement of states to publish the materials electronically.
I see. Thank you very much. All right. I guess we will be followed by Ms. O'Connell.
Yes, and I will speak just very briefly. I am Jane O'Connell. I'm the Deputy Director at Tarleton Law Library at the University of Texas School of Law. Additionally, I'm also a member of the American Association of Law Libraries Digital Access to Legal Information Committee that strongly supports the adoption of UELMA. I am here purely in a personal capacity, but I would strongly encourage the adoption of the Uniform Electronic Legal Materials Act for the numerous reasons that Professor Bentliff spoke on. So thank you for your time and consideration.
Thank you. Members, any questions? All right. Thank you very much. Let me see. So do we have a preference? Go ahead.
Good morning. My name is Mary Camp. I'm the Director of the Legislative Reference Library. Thank you for having me today. I guess the only documents that we feel that would fall into this category possibly would be your legislation, the original bill files, which are housed by the library ultimately. They come to us from the Chief Clerk's Office and the Secretary of the Senate, and then they're held forever in the library, and it's the historical document of record. One of the things we do is certify copies of those bills, whether they passed or not, for court proceedings and other official meetings. The only other items of interest in our library that we feel would fall into this category would be, as Professor Bentliff mentioned, were the session laws, and then again the House and Senate journals. One of our only concerns, or our only question, is if we make all of these available electronically, that we still maintain the hard copy for the official record purposes. And as the technology continues to change, we just wanted to make sure that everybody has access to them. And we know from our library standpoint that not everyone has access to a computer. So sometimes a hard copy is the only way they're able to come in and see a document. And also when you lose power, you can always pull a book from a shelf or a file from a cabinet. You can't always go back to the electronic version. And that's really all we have to say. If you have any questions.
All right. All right. Representative King?
Mary, I just wanted to say I appreciate what the library does for all of us. It certainly makes our life easier. Thank you.
Thank you for saying that. Chairman Lewis.
Yes, I echo the remarks of King, and I also like books. So thank you for at least putting in books.
You're welcome.
Those like me who like to open a book and read from a book. But on this topic, are there any things about the uniform, and I'm talking about you and your individual passages, you as a person has to administer these types of things. Is there anything about this act that, in looking at it or considering it, you think, gee, this would put a burden on me, or this could put a burden on another agency, and, well-intentioned, but we ought to look at this or that could have some consequences? Was there anything like that went through your mind, or that you just have a concern with, that we ought to at least look at in the wording of this act?
Well, I guess the only thing that, and we haven't really talked about this at any length, is just who's responsible for making these available, at what level and at what point in time, so that if it's the library, we would have to have more dedicated staff or equipment to make sure that we're able to upload, or work with the Secretary of Senate or State's office to make sure whatever they have is available. So I don't see a big burden at all, but just coordination with existing staff.
Thank you very much, Ms. Camp.
You're welcome.
All right. Members, any other questions? Oh, Chairwoman Thompson.
Ms. Camp, thank you for your long service to the state.
Oh, you're welcome.
Let me ask you about electronic filing. How does that impact your job?
Well, we've been working with the council hand in hand with the e-filing effort, and we feel that all of our needs are going to be met. We're able to have the hard copy as well as process through the electronic filing. So I think this will be our first session to go through this, but I think it's going to be fine. We support that effort completely.
Thank you. So you will be able to maintain your hard copy?
Yes, ma'am.
Thank you.
Thank you.
Thank you very much. All right, and we have Lisa Rush.
My name is Lisa Rush, and I manage the Travis County Law Library here in Austin, and I'm not speaking in official capacity for Travis County. I want to talk to you about the paywall that exists between citizens and their laws. They are expected to follow these laws, but it costs money to access the official copy. Now, from the American Association of Law Librarians publication on ULIMA, it says that ELMA offers the framework for providing the official legal material online with the same level of trustworthiness traditionally given to print publication. The print publication costs $7,500 a year. That's out of the reach of many of the public libraries in our small towns in Texas. That's certainly out of the reach of a lot of individuals. That's $7,500 a year. Now, you ask about the effect on Lexis and Westlaw. Their primary customers are attorneys and judges who are paying for the annotations that they add. I don't see them being affected by regular, normal people having access to their own laws. $7,500 a year for print publication. My library would still purchase at least 1 or 2 copies of the print publication for all the reasons you mentioned, and because, like you, Representative Lewis, we're librarians, we still love the books. But wouldn't it be wonderful if the public library in Marfa, Texas could offer access to official copy of the state's laws to its citizens? I think that would just be wonderful. Thank you.
All right, thank you. Members, any questions? All right, thank you very much, panel. Appreciate you. All right, we have panel number 2, and the chair calls the next panel Dan Proctor with the Office of Secretary of State, David Slayton, the Office of Court Administration, and John Heining from the Texas Legislative Council. And whoever would like to begin would be fine with us.
I'll volunteer.
All right.
Mr. Chairman, Madam Vice Chair, and committee members, I'm Dan Proctor, and I serve as the Director of Government Filings Section for the Office of the Secretary of State. And as the Secretary's designee, I chair the Records Management Interagency Coordinating Council, which studies and reports on records management matters on state government and higher education. Thank you for an opportunity to address this important topic today. The Secretary of State is statutorily responsible for the electronic publication of the legislative bills. Those are the signed copies following each session of the legislature, and for the state agency rules in the Texas Register and the Administrative Code. These electronic publications that are published on the Secretary of State's website are convenient, they're timely, and we think they're reliable. People who use this information seldom question the integrity of these online documents, but these documents are not official. The official versions are on paper. The original paper versions of the legislative acts, after we publish them online and preserve them in microfilm, are bound and go to the state archives. The original paper versions of state agency rules, once we publish them, are maintained by the Secretary of State in a permanent register. Also, digital archives of the legislative acts and the Texas Register are stored with the University of North Texas and, and available online through UNT's Texas History Portal. Any of these documents can be certified from the original copies. For those who want books, printed editions of the session laws, the Texas Register, and the Administrative Code are available from commercial publishers such as Thomson Reuters Westlaw, and from LexisNexis. At present, the Secretary of State employs no method for online users to verify the authenticity of these documents. But implementing such a feature appears to be achievable with a reasonable effort. While making myself more familiar with the Uniform Electronic Materials Act, I learned that a handful of states have already implemented different applications, some using do-it-yourself hash algorithms and others using off-the-shelf software. Colorado, for example, opted for an Adobe Acrobat authentication method. Utah and Minnesota have each developed different methods using in-house resources. The newly created nonprofit called the U.S. Open Data Institute, which I think was mentioned a minute ago, and I talked to its director last week, and he says they're going to offer a solution soon that would answer the question, is this file trustworthy or has it been tampered with? I would direct the committee to my written testimony on this interim charge for a more complete discussion of the legal publishing functions of the Office of Secretary of State and the resources that are available from the Records Management Interagency Coordinating Council agencies. Again, thank you for allowing me to testify on this matter, and I'm happy to take your questions.
Members, any questions? Thank you very much. All right, David?
Good morning, Mr. Chair, Madam Vice Chair, and members. My name is David Slayton, and I'm the Administrative Director of the Office of Court Administration. As you know, the courts are fairly decentralized in Texas, and of course the records that would be subject to the Uniform Electronic Legal Materials Act, if these records were maintained in electronic format only, would be court records, opinions, and rules that the Supreme Court or the Court of Criminal Appeals were to issue. Just want to give you a little bit of a brief indication. Right now, similar to the Secretary of State, there is no uniform system of authenticating court or legal documents within the judiciary. Each court follows their own guidelines, with a majority of courts at both the trial court and appellate court levels retaining signed original copies of orders and opinions, which are designated as the official record, so that authentication of electronic materials can be done against the original. As you also probably know, there, at least at the appellate court level, basically almost all court records are now posted online and available via the Texas court's website. And at the trial court, a number of local courts have also established such a way to check that online. As far as the specifics for each court, the Supreme Court actually stores a original copy of the opinions and has kept in a case file. They, of course, also put that online as for public review. Court of Criminal Appeals does the same. They also keep their original. If you look at the appellate courts, it's actually kind of different depending on which court you're at. Most of the courts keep the original signed copy for permanent retention and also place the electronic version online. But three of the courts, the 3rd, 4th, and 13th Court of Appeals, keep the scanned electronic copy for original, so the electronic version becomes the electronic version is available, and the 12th Court of Appeals actually has designated its electronic version as the official version, but keeps the original paper on file. So we really have a variance among all the courts. The Supreme Court's rules that were passed last December regarding electronic filing allows clerks at all the different court levels to establish the electronic version as the official version and does not require them to retain paper. So the issue of authentication does actually become something that we should take a look at. As far as OCA, any forms or documents that we have, or the Supreme Court's rules that are on the website, there currently is also no authentication available for those. As far as other states, you've already been told how many states have enacted the Uniform Act, but not all states have actually even addressed the judiciary in its enactment of the statute. Only 3 of the 9 states, Connecticut, Hawaii, and Idaho, have included the judiciary's records in its passage of the Act. Connecticut actually defines legal materials that are subject to the Act to be decisions by the Supreme Court, the appellate courts, and the superior courts, and designates a uniform statewide Commission on Official Legal Publications as the publisher of the official materials. Hawaii designates the decisions of the state Supreme Court, the intermediate appellate courts, and state court rules as subject to the Act, and designates the Supreme Court as the publisher of the materials. And lastly, Idaho designates the legal materials to be the decisions of the Supreme Court, the intermediate appellate court, or state court rules, and designates the clerk of the Supreme Court and the Idaho Code Commission as designated publishers of the records. One alternative is that the state of Arkansas has not adopted UALMA, but in 2009, the Supreme Court of Arkansas became the first state in the country to make its electronic version of its appellate decisions posted on their website as the official report of the appellate rulings. So they're providing a level of authentication as part of that. As was reported by the Secretary of State's office previously, we've taken a look at this and think it would not require any significant effort to accomplish this. The one thing I would mention is that as we've looked at this, we realize that different state agencies may have different ways of wanting to authenticate, including the judiciary. And so, to the degree that the legislature wants to require authentication, I think we have no issue with that. But the methods may be something that you all might want to allow the agencies or the judicial branch to decide which method they're used, because there are multiple methods to doing so. So that's I would answer any questions you might have at this point.
Madam Chair Thompson, sorry.
You mentioned Arkansas keeping their appellate decision in that particular method. Is there a cost saving?
Well, there would certainly be a cost savings just strictly from a storage standpoint. So in Arkansas, of course, that would mean there is actually no paper version of those opinions. And to the degree that the courts or any other agency, I assume, went strictly to electronic, the storage would be the primary. There'd be some paper cost, obviously, but the storage, I think, would be the biggest savings. We're seeing that at the trial court now. I was actually at a clerk's conference last week, and I asked them to raise their hand. There were a bunch of all the clerks were in the room, and a number of them have gone strictly to the electronic version, and of course that's where significant cost savings comes in, because now with us having electronic filing, these documents are coming in electronically and can be retained as the official version in that format without ever going to paper and without there ever being storage costs. So obviously there is significant cost savings when you're talking about a large volume of documents.
But if it comes into question, you don't have anything to validate it against.
So that's the reason why this act is something that I think we all should take a look at, especially as we move towards the electronic version being the only one, is the way that the validation works is that the end user would be able to validate. So if we posted an opinion, a Supreme Court opinion that was issued last Friday, if we posted it online with an authentication like the hash value, that any user who pulled that up could verify that hash value to make sure they're the same, so that it would indicate that there had been no alteration of the opinion between the time that we posted it on our website and the time they reviewed it. And I think that's something that is critically important, so there can be that authentication, so the end user knows that the document they're looking at is the official version from the beginning.
Thank you.
Chairman Lewis?
Yes, Mr. Slayton, just, I think, I don't know if I understood or didn't understand something I want to ask you. Did you say that the courts of appeals, the different courts of appeals, have different rules with regard to what they put, their electronic publication of materials?
So the courts of appeals have the rules that the Supreme Court has passed allows the courts of appeals to determine which version is their official version. All of the courts of appeals post their opinions now through the Thames portal, which you may be familiar with. That's the statewide portal for appellate court materials, briefs, opinions. So all of them are posting that information online, but some of them are also retaining a paper copy. Some aren't. Some are designating the paper copy, even when they're posting it online, designating the paper copy as the official version. At least one court, the 12th Court, is actually designating the electronic version as the official version. So that's where the differences are coming in. They're all posting online. Everyone has it online. Some of them are retaining paper, some aren't, and then the differences in which one's the official version are where the differences are in the courts of appeals. And I presume at some point there will become more uniformity. Of course, we're still fairly early on in the courts of appeals, for instance, with e-filing and other methods. So I suspect that over time those will become more uniform.
And you have it on your paper here that's been handed to me, and I appreciate. But as far as the Court of Criminal Appeals, would you just go briefly over their electronic verification or whatever?
So the Court of Criminal Appeals actually stores the original paper copy of all their opinions and orders. They are also posting their opinions online, but the paper version is still the official version. And the way the Act reads, just to make sure we're all clear, is the Act doesn't really trigger as far as authentication until you designate the electronic version as the official version. So as long as you have a paper version to authenticate against, there's not a whole lot of requirement for authentication. It might be a nice thing to add for users who are, for instance, in West Texas or East Texas and don't want to travel to Austin to make sure it's the same. But the Act really, the way it's written, is it really triggers whenever you designate the official version as electronic version, which, as you see, at least some of the courts are now doing across the state. So something we need to take a look at.
Thank you very much.
David, there is a cost, though. I mean, there's not a paper cost, but there's the cloud or wherever it's stored. As we all know, that I am constantly asked to upgrade my cloud storage, for instance. And so, can you speak to those sorts of costs?
Sure. I guess for at least us at this point, from the judiciary's perspective, we're already storing these documents electronically anyway, so it wouldn't be an increased cost to do something like this. Obviously, if you're in a place where you're not storing any documents online at all, and you begin to move to that place, then you would have an increased cost of making sure you have the storage. Of course, the alternative argument to that is that to store, at least from court records perspective, to store electronically and to buy space on the cloud or buy storage space in an office somewhere is much cheaper than actual physical storage. So the rows and rows and rows of actual physical space is much more expensive than buying the electronic space. So to a degree that there's individuals who are not currently posting these records online, there could be a cost up front to do this, but it's in most instances we've found it's been cheaper than the physical storage space.
Sure. And then I'm sure you have to have systems in case, like we're supposed to have at home, where you back things up into something else. And so
absolutely, the replication has to be in place to make sure, and obviously the worst thing would be is we have to ensure that if, for instance, the 12th court's system goes down, and let's say that there's some issue with it, we have to make sure that there's a way to recover their opinions, because obviously we wouldn't want to lose however many opinions are out there that have been issued in the electronic version. So we have to ensure those replication places are in place. The nice thing is this is becoming cheaper and cheaper as more and more individuals and entities move to electronic storage.
Thank you. Members, any other questions? All right. Moving onward.
Hello, Mr. Chair and Madam Vice Chair and members of the committee. My name is John Heining. I work for the Texas Legislative Council, and I appreciate the opportunity to speak on this issue with you. The Texas Legislative Council maintains two sources of materials that I think might be pertinent to our discussion here. The first is on our Texas Legislature Online web application, where nearly all legislative proposals considered by the legislature, analyses from various legislative entities, votes, actions, and other information are available. In addition, we also maintain the Texas Constitution and Statutes web application, which is a free online compilation of the statutes and Constitution of Texas. And it's essentially a byproduct of our services to you, the legislature. We need to, in order to amend the statute, to draft a bill, we need to know what the status of the law is. And so we take the statutes that you passed in a previous legislative session and incorporate them into our databases, so that then when we're drafting a bill, we know what the law is and we know how to amend it for you when you ask us to draft legislation. And the way that we do that is we have created a bespoke computer program that actually identifies the recital in each bill that passes, and then incorporates whatever changes underneath that recital take place into the code and into our statutory database. That database is then checked by our editors for accuracy, and then our lawyers will analyze any conflicts that might take place, and then finally our IT staff enters those updates both into our internal drafting database and then onto TCAS, the Constitution and Statutes web application. That TCAS web application is published in February or March of each even-numbered year. Of course, when we have special sessions, that tends to push it out a little bit further naturally. One thing that I want to point out is that neither of these databases is official. With regard to TILO, as Mary Camp mentioned, the official bills and resolutions are generally in the hands of committee clerks, the chief clerk, the secretary of the Senate, or the legislative reference library, depending on what part of the process we're in. With regard to TCAS, the adopted statutes and constitutional amendments are in the Secretary of State's office or in the archives. There is no official version of a compiled Texas statutes or constitution. In fact, the Texas Law Review publishes its Green Book, and they recommend citation to the Vernon's Texas Statute and Codes Annotated, and our web application is specifically disfavored for citation purposes. So things that you might want to consider when we're moving forward here is that neither the sources that we maintain are official, but as has been discussed, other states have made their compilations official. Usually that's because the state already was officially publishing its compilation. If you want to do that, we can certainly do that. If we move from this being kind of a byproduct of our services to you to an official mandate, the Ledge Council, would be a little bit concerned, or we would have questions we'd like to work out with you about how quickly you would like to have this official publication produced, whether or not the application needs to be changed in order to adjust for citation and authentication purposes, and then of course that's going to have an impact on programming and staffing for us. We would, of course, want to work with you to make sure that in supporting this new responsibility, there would be a minimum impact on serving our core purpose, which is, of course, serving you, our clients. In addition, we provide IT support to other legislative agencies, for example, the Legislative Reference Library. So any mandate that this proposal might place on them would, of course, indirectly impact us because we'd be helping them get done whatever they need to do. With regard to TILO, those are copies of legislation. They're not, they're not generally photographs of the official legislation there. And if you decide to make TILO the official repository for legislative documents available to the public, that would be a fairly significant change in processes. I don't know, I have no idea what all the changes would be there, but that would be something to consider. For general recommendations with regard to this proposal, it specifically does not endorse any specific technology as a solution, and we, as your IT professionals, we think that's a really good thing. One other issue that we've come to deal with on a regular basis is that the automating and digitizing physical processes, to the extent that that would be required by this legislation or that would be anticipated by what you would want to do, very often those processes are much more complex than were initially anticipated, and so we would recommend that you provide plenty of time for implementation and a pilot program if that was appropriate. And then with respect to legislative documents, want to point out that a change in law may not be necessary. We, as legislative agencies, work directly for the legislature, so legislators can, if they choose, make changes to our services by working through each legislative agency's standard service enhancement processes. And that's all I have to say, unless you have any questions.
All right. Members, any questions? Thank you very much, panel. We appreciate you.
We also received a letter from a librarian who wasn't specific.
Okay.
Which library?
Yeah. Could I just ask that? Madam Chair, I don't know if there are other witnesses, and I'm sure you'll be asked if there are other witnesses on this matter, but I did want to ask that a letter from Spencer Simmons be placed on the record of the committee. I received this morning, and Mr. Simmons is a law librarian. He wrote a letter in favor of, in support of the Uniform Electronic Legal Material Act. I don't read the whole letter, but it concludes, a law librarian for 20 years, I'm especially aware of the importance of enacting UELMA. Law libraries assist others in using electronic materials every day. I have seen the problems caused for students, scholars, and attorneys when electronic material is changed without notice and when the authenticity of electronically based legal documents cannot be relied upon. So I would request that this be placed on the record, Madam Chair.
Certainly.
Do I need to say anything official to accept it for the record?
Okay, great. All right. Is there anyone else that wishes to testify on this charge? All right. Hearing none, we will move on to